thank everybody for coming. This is the Levin Ginsburg webinar for February 23rd, 2022, presented by myself, Kevin Thompson. The title for today is Trademarks and the Likely to Confusion Test, in which I'll be talking about how that particular test is applied in U.S. trademark cases, focusing primarily on the USPTO, but we'll talk a little bit about how the standards might differ in other jurisdictions as well. Today we'll be talking about just some basic trademark basics, because I don't assume everybody has the same knowledge about trademarks. We're going to talk a little bit about distinctiveness. We're going to talk about the likely to confusion test and give some case examples. So just basic trademark. Trademarks are symbols used in commerce to identify the source of particular goods or services. The rules and regulations depend a lot on from jurisdiction to jurisdiction. Here we'll be focusing on federal trademark registration that's through the U.S. Trademark Office. Mark is entitled to federal registration if it is in use in commerce, or depending on some other bases for registration, but the most common use is use in commerce. That's the most common basis. There are different degrees of distinctiveness for trademarks. There's the generic terms, which is the industry term for a particular good or service, all the way up through distinctive or suggestive or coined marks, such as like a Kodak, which was a made-up word, which was then got distinctiveness through use. So there's marks that are considered suggestive, which is they might describe a particular good somewhat, but it might just more be rather than be truly descriptive, it's suggestive of the particular good. Then there's marks such as Apple, which are arbitrary. There's no distinction for apples in, let's say, music, or in the case of the Beatles, or Apple in the case of computers, in the case of the Apple computer. So Apple is a arbitrary word. It's gotten distinctiveness through the use there. So in particular, you will be focusing today on likely confusion, in which we'll be talking about the differences between two trademarks and how courts and the USPTO come to decide if there's a dispute, who's entitled to registration and who isn't. So in the USPTO, there are 13 factors that come from the case of EI Dupont de Demurs. So they're generally referred to as the Dupont Factors. These factors might vary from jurisdiction to jurisdiction. In the case of some circuit courts, a lot of them follow similar factors, but they may or may not follow the exact same. And so it's up to you to keep in mind what jurisdictions you might be in front of and know what the rules are. In this case, we'll be talking primarily about the USPTO, so we'll be talking about the Dupont factors. Here's a case description from the Muddy Leaf case. It says basically that the likely to confusion inquiry is extremely fact-specific. Not all factors are relevant to every case, and only factors of significance to the particular mark need to be considered. So while there are 13 factors, you don't necessarily have to look at all 13. In fact, sometimes the cases are generally decided by the first 3 or 4 factors. The first one that comes up is the similarity of appearance, sound, connotation, and commercial impression. And that is when you compare the two marks, how do they appear? Are they the same appearance, the same number of characters, the same syllables? Sound, are they pronounced the same? Connotation, what's the meaning? Is it a particular phrase that's used to mean something? Is it a particular word that's used to mean something? And then the commercial impression is generally, how does it appear? Does it appear to be similar in overall appearance? And here's some language. The proper test is not a side-by-side comparison of the marks, but instead whether the marks are sufficiently similar in terms of their commercial impression, such that the persons who encounter the marks will be likely to assume a connection between the parties. Ultimately, it goes back to one of the purposes of trademark law. One of the major purposes is to allow consumers to know what the source of the goods they get, where they purchase from, and so that they know who to complain to if there's a problem. And so, or if they would like to purchase something, they might have heard that there's a particular brand out there, and they might remember one part of the mark and be confused because it's the same part that they might remember. The other part of this is the appropriate emphasis on the recollection of the average purchaser, who normally retains a general rather than a specific impression of trademarks or service marks. So somebody might generally remember that there's, some sort of cola product out there that they want to purchase, and if there's a Coca-Cola, there's a Pepsi Cola, and so that they would know just between that, there might be similarities there. But again, in that case, the cola is a generic term, and so the distinction will be a Coke or a Pepsi, in which case, there wouldn't be confusion between those particular two. The second factor is the similarity of the goods or services. And this is where you look at the four corners of the application or registration, and you look at what the goods actually are. And the goods do not have to be identical or directly competitive to support a finding that there is a likelihood of confusion. In this case, what you look at is just what are the goods, what are the services, is it possible that somebody might purchase them in a similar context. Next is you look at the similarity of trade channels. Where are the goods sold? What sort of marketplace? And then how sophisticated are the consumers in those trade channels? Another factor you look at is the conditions under which sales are made. Is it an impulse buy? Is it like a low-cost item that you just see quickly and snatch off the shelf? Or is it a sophisticated purchase where you sit down and there's millions of dollars at stake, and what you would do is have a long negotiation, and over the course of negotiation, you can certainly discover that you're bargaining with the right entity. So if it's an impulse purchase, it's more likely for there to be consumer confusion, but it's not automatic. So certainly, sophisticated purchasers can also be confused. The next two factors are related. One looks at the fame of the mark, what sort of sales, what sort of advertising, how long they used it, and then looks at how crowded the marketplace is, the number and the nature of similar marks in use on similar goods. And in this case, the language here, it looks at both inherent strength, which is based on the nature of the mark, and commercial strength of recognition of the mark. And then those two factors are related. It looks at how famous is the mark, and how crowded the marketplace is. The seventh and eighth factors are also related. Whether or not there's any evidence of actual confusion between the two brands, and then one looks at the length of time and under conditions in which there's been concurrent use. And of course, if there is evidence of actual confusion, that would be highly, probative of the issue, whether there is. But a lot of the times, there isn't actual evidence on these two factors. It's interesting when there is. And one of the cases we'll be talking about has this. Next, we look at the variety of goods in which a mark is or is not used. Is it a house mark, such as a major brand, a family mark, if there's like a series of products that incorporate part of it, or is it just, one-off product? And then the next factor they looked at, what's the market interface between the applicant and the owner of the prior mark? Is there a consent agreement? Is there prior contract? And again, one of the cases we'll be talking about today There's where the significant interactions between the two entities before any allegations were made of confusion. Next factors are looking at the extent to which the applicant has a right to exclude others from the use of its mark on its goods. It looks at factors like, whether or not like the applicant owns like a prior registration, and then look at the extent of those potential confusion, whether it's minimus or whether it's potentially substantial. And then the 13th factor is their catch-all. It's the factor that pertains to any established fact that's probative of the effect of the use. And if there's something that comes up that's unique to the particular situation, that based on these particular facts that the fact finder finds informative, that's where that 13th factor can come in. So today, we're going to be focusing on some cases that were decided in the last year by the Trademarks Style and Appeal Board, and had a likely to confusion element and were found to be precedential by the TTAB. And in that case, what that means is that these are cases that can be cited in other decisions, and there's a lot of the other cases, even non-precedential ones, can be brought up. But there you've got to really go to your, show what particular factors and why, that particular mark is important enough to be talked about. In that particular case is important enough. In this case, we'll be talking about some precedential ones. The first one is a case between Brooklyn Brewery Corporation and Brooklyn Brew Shop. This is one particularly interesting. It was two proceedings that were consolidated together. One is a cancellation that was brought against a prior registration of Brooklyn Brew Shop. And then there was an opposition that was filed against their current application. Brooklyn Brewery is a longtime famous brewery in Brooklyn in New York. And they have a lot of, fans of their beer. One of their fans is Brooklyn Brew Shop, which is a company also based in Brooklyn, which makes beer making kits. And what makes this kind of an interesting fact situation is these companies had worked together for a period of time. And at one point, Brooklyn Brew Shop made a beer making kit, several beer making kits that were Brooklyn Brewery branded. So certainly the parties were aware of each other, and they found, to have a decent working relationship for several years. It really was only when Brooklyn Brew Shop started to expand their use and started to get involved in actual making of beer that Brooklyn Brewery started to complain. And so they brought these two proceedings. And a lot of the decision that the TTAB came with is on a slightly separate issue, which is the doctrine of laches, which comes up basically Brooklyn Brewery, because of their long relationship already with Brooklyn Brew Shop, was found ultimately to be stopped from complaining about the beer making kits because of this relationship. It would be a hardship on Brooklyn Brew Shop after these years of working together and then developing the brand together for them to be stopped from using Brooklyn Brew Shop. Ultimately, what remains is whether or not they could then complain about their Class 5 or Class 21 goods. And in this case, there certainly are some interesting factors here. If you look at the first factor is the comparison. Brooklyn is in both marks, and Brooklyn is a geographic term. So it's a highly descriptive term geographically for that particular area of New York. And brewery is the generic term for the particular function, making the beer. And similarly, brew shop is more suggestive, but it involves brew. And they would be, certainly descriptive of the function of these beer making kits. And what was interesting about this is that when you look at the next factor, which is the goods, they're really that was not presumed. Class 5 is for sanitizing preparations, which is the cleaning product that they would use to clean something before the beer making kit would be used inside the vessel. And it was not found to be likely of confusion between the two because there was generally no overlap. Generally speaking, a brewery wouldn't necessarily automatically be selling sanitizing preparations. And then they were able to object to their application for the glassware. In the case, they were both, one had a prior registration for the beer mug, and they were able to stop that, but they were not able to stop them from the sanitizing preparation and from the beer making kits, again, because they were stopped from that particular argument. So it's a really interesting case. There's a lot of really interesting facts here dealing with the long history between these two companies, and it's really interesting reading. The next one, Sacatoomi Inc. versus Iping Fan. And the two phrases that were here, the registration was Sacatoomi, and the applicant was trying to register Sock It Up. And both is in the same class 25, socks and stockings versus socks. So in this case, this is one of those cases where the goods, the second factor, the goods were identical. A lot of the rest of the analysis focuses on the remainder of it. The word sock is generic, but it's used as part of a phrase. And in this case, they both have the phrase sock it in it, but then it's sock it to me is the registrant, and sock it up was the applicant. And they have different meanings. Sacatoomi could be evocative of somebody involved in a fight, or somebody with a lot of grit or determination, versus sock it up, which is more of a phrase similar to suck it up. You have internal fortitude, something along those lines. And so therefore, they're slightly different phrases, both made up of generic terms. A good part of the decision is focusing on a different fact. It's interesting for basically the opposer was trying to claim that the applicant hadn't really used the mark in commerce, and there was a long discussion about their use through a third party, which was a related company, and ultimately was found to inure to their benefit. So this use by their related company was sufficient to show use. So it was certainly an interesting decision on multiple levels. But we're focusing on the here, and ultimately it was denied. The opposition was denied because Sacatoomi and sock it up mean different things to people, and was not related enough for there to be sufficient confusion. So this was an interesting one where likely confusion was denied. The next case is Mahender Zabani versus Mirage Brands. This is an interesting one where there's both parties have registration, and what had happened is the one on the left with a prior registration had been around for a period, and in the meantime, this Mirage Brands gotten their registration for perfumes and colognes. And they got past certainly the examination stage, but then these people brought a cancellation action after it. It's a interesting factors on several levels. One of them deals with the fact that they're both perfume companies, and the one on the right is more of a mass product, a competitor that had come in, a low price competitor. So one on the left is a much more expensive product, and in the meantime, these people had come in with a a low cost competitor that was actually getting a lot of traction in stores and so forth. And so these people brought the cancellation action to try to stop them from using this. And when you look at it, you look at the factors here. There's differences certainly between the commercial impression. The registration on the left encompasses this rectangle, which is the I think it's supposed to be evocative of the packaging, and so there's the words Royal Mirage, and then sort of an image of a crown that's all together. And here, one on the right, they have a word mark for Mirage brand, and they also have a design mark, which has got a stylized M with flames coming up from it, with the words Mirage brands, with emphasis to focus on the word Mirage and the M. And in this case, what you look at is what's the strength of the word Mirage for perfume. And Mirage is certainly not descriptive. It's potentially could be distinctive on its own. If you look at the differences between the two, there's Royal Mirage versus Mirage brands, and so the focus on this is the one on the right is that they have the word Mirage as the dominant portion of their mark, which is the part because the consumers would focus on it. It's certainly in the largest print in their logo, apart from the M logo, but certainly brands is a diminished word. Royal Mirage, they were focusing on the differences between Royal Mirage and Mirage brands, and the factors here are that certainly Mirage is strong enough, and Royal was not too much of an impact. Royal just means part of the royal family, or part of royalty, and so therefore, certainly Mirage is a dominant portion of the market on the left as well. And since the one on the left had priority, they were able to seek cancellation, and in fact succeeded. So they brought cancellation action and won against both of the registrations on the right. Kind of fun fact. This next case, Charter Inc. versus Great Concepts LLC and Great Management Group LLC. Kind of interesting. The one on the left is a common law mark. It's for a restaurant that's in Hollywood, and it's apparently a famous restaurant that's frequented by a lot of Hollywood celebrities. And the one on the right is a restaurant, I believe, in Atlanta, Georgia, and they had brought the opposition in. They actually sought cancellation against a prior registration that had come up in there, and we won't go into it too much, but one of the counts against the cancellation was the fact that the Section 15 filing had been made at a time when they couldn't truthfully say that there was no proceedings involved against that particular mark. You're required to file a Section 8 to maintain the mark, but you're not required to file a Section 15. One of the parts of the 15 is to, saying you've been using it consecutively for the past 5 years, and nobody you're not involved in any proceedings against the mark. And what the case focuses on is their knowledge of the fact that they were involved already in a proceeding, and so they got a false Section 15 claim. And what ended up happening was the board canceled the registration, saying that they made this filing with reckless disregard, and therefore was sufficient for them to show fraud in their filing. So the registration was canceled. And then it ultimately then just goes down to what's the likely confusion between Dan Tana's, this restaurant in Hollywood, and Dan Tana's, pronounced the same but spelled slightly differently, which was a restaurant in Georgia. And in that case, what they found was that certainly there were similar phonetic usage between Dan Tana's and Dan Tana's, and since the restaurant on the left had been using it since the 1960s, they had priority. They were able to cancel, and also to sufficient for them to succeed in their opposition. Kind of fun, interesting facts here. This next one is also kind of fun. In Joel Ambin, the applicant is involved. He's a professional basketball player with the 76ers, and he's known informally as the Process. That's his nickname. And so he brought this application for registration for shoes. In the meantime, there's a registration already on the books for Trust the Process, the same exact mark in Class 25 for clothing, namely shirts and sweatshirts. And this registration is owned by a, I believe it's the host of a CNBC financial show called The Profit, and he uses Trust the Process in his marketing. And so he has this registration. In this case, a lot of the facts go for the fact that, essentially the marks are the same, the goods are related, but the trade channels are quite different. So the one on the left is, used to support the professional basketball player in his merchandising, whereas Trust the Process is used on the right by the CNBC host for their financial services. Ultimately, what you look at is, how close are the marks? Well, they're the same. Well, how close are the goods? Are they related? Well, shoes and shirts and sweatshirts are definitely related. They're in the same class. And it doesn't really matter in this case how different the trade channels are, because without limitations on it, they're presumed to operate in the same trade channels. If there was a limitation in there, like shoes, limited only for the filing of good or use with goods related to professional basketball, or the one on the right was limited to clothing, namely shirts and sweatshirts, only in promotion of financial services, then that might have been allowed to go through. But in this case, that was not before the board, and so they denied the application to proceed. They upheld the examiner's citation of the Trust the Process registration. Interesting facts, and we'll have to see whether or not the one on the left gets reapplied for with a limitation. Kind of fun. There was one case I actually wanted to talk about, but it actually focuses more on the delusion statute. There's a recent case with Spotify versus Spotify. And the Spotify is, of course, the famous music service, and Spotify was a application brought by an owner of a marijuana dispensary. And basically, although likely the confusion was alleged, ultimately the case was decided on whether or not it would dilute the distinctiveness of the famous brand. And so I'm going to save talking about that one in for a future webinar. A lot of interesting facts there. So what I'm going to do is open it up to questions if there are any. First question is, would Royal Mirage fall under the arbitrary or suggestive category in the trademark hierarchy? I would say it probably falls more under the arbitrary, in that Mirage is not descriptive. Royal probably would be a little bit more suggestive in that when you apply it to perfume, it implies a level of distinction, sense of involvement with the royalty. So then that's how that probably would fall under there. Your next question is, does likelihood of confusion apply differently to marks that are inherently distinctive than to those that require secondary meaning? And the answer to that is it really depends on what the marks are, but generally speaking, when marks are inherently distinctive, they are analyzed slightly differently by one of the factors, and that it looks at the strength and the distinctiveness of the particular marks. I believe it was the factor focusing on the markets and just how distinctive those particular marks are in those particular areas. In that case, if the mark's inherently distinctive, they're probably not in a crowded market, and so therefore, the other marks might require more secondary meaning in order to go forward. Good question. If there's no other questions, I think I'm going to go ahead and end the webinar. And I'd like to thank everybody for attending. And the webinar will be posted shortly, hopefully. Thank you, and have a great afternoon.